For this video, we are going to discuss Article 163 of the Revised Penal Code, which involves the crime of making and importing and uttering of false coins. But before that, allow me to enumerate the crimes under counterfeiting coins, which is found in Section 2 of Title 4, still under Crimes Against Public Interest. They are, number 1, which will be our topic for this video, the making and importing and uttering of false coins, Article 163. We also have Article 164, the mutilation of coins, including the importation and utterance of mutilated coins. And last but not the least, we have Article 165, which is the selling of false or mutilated coins without connivance. Let's start with Article 163. Here is the penal provision of the said article. Any person who makes, imports, or utters false coins in connivance with counterfeiters or importers shall suffer the penalty of prisión correccional in its minimum and medium periods and a fine not to exceed 400,000 pesos if the counterfeited coins be any of the coinage of the Philippines, and the penalty of prisión correccional in its minimum period and a fine not to exceed 200,000 pesos if the counterfeited coin be currency of a foreign country. These are the elements of Article 163. First element, that there be false or counterfeited coins. Second element, that the offender made or imported or uttered such coins. And third element, in case of uttering such false or counterfeited coins, the offender connived with the counterfeiters or importers. There are 3 punishable acts in Article 163. What are they? They are the making, the importing, and the uttering of false, fake, or counterfeited coins. Let us discuss the first punishable act, which is the making of a false, fake, or counterfeited coin. Now, to make a false coin means to counterfeit. Question: when is a coin false, fake, or counterfeited? Answer: it is counterfeited if it is forged, regardless of its intrinsic value. Counterfeiting means imitating a legal or genuine coin. The false or counterfeited coin may even contain more metal than the genuine coin. What is important is that there is an imitation of the peculiar or particular design of a genuine coin. Example: X has 4 10-peso coins and 1 5-peso coin. Even if X knew that he had only 45 pesos all in all, he was able to purchase an item at a sari-sari store in the amount of 50 pesos. Question: is he liable for the crime of counterfeiting? The answer is no. But he can be held liable for estafa, but we will discuss the crime of estafa in our future videos. Why is he not liable for counterfeiting? He is not liable for counterfeiting because he did not use the 5-peso coin to imitate a 10-peso coin. What happened was X made it appear that he had 5 10-peso coins, and the seller or the store owner was made to believe that X exactly had 50 pesos when these coins were turned over to him. But in truth and in fact, like what I said a while ago, X only had 45 pesos. The 5-peso coin itself is a genuine coin. There was no counterfeiting, or rather there was no making of a false coin. What X gave was a 5 peso coin. The 5 peso coin is a genuine coin bearing its original design and inscription. So the example shows that X did not counterfeit because he did not imitate a legal or a genuine coin. Let's go to the second punishable act, which is the importing of false, fake, or counterfeited coins. To import false, fake, or counterfeited coins means to bring them into port. This also presupposes that the counterfeiting was done in another country or outside the country, such that the one who caused the importation is the one held criminally liable. If the counterfeiting was done by the offender outside of the country, let's say in Malaysia, can he be prosecuted here in the Philippines? The answer is yes. Forging or counterfeiting any coin or currency note of the Republic of the Philippines or obligations and securities issued by the Philippine government is one of the instances where the Revised Penal Code is given extraterritorial application under Article 2, Subdivision 2 of the said law. Extraterritorial application means the provisions of the Revised Penal Code shall be enforced not only within the Philippine archipelago but also outside of its territorial jurisdiction. Example number 1. X counterfeited 10,000 20 peso coins while he was in Singapore. Question: can he be charged and tried for counterfeiting here in the Philippines? The answer is yes, by virtue of Article 2, Subdivision 2 of the Revised Penal Code. To repeat, this is one of the instances where our Revised Penal Code can be enforced even outside of our territorial jurisdiction because it is given extraterritorial application. Example number 2. X counterfeited 10,000 20 peso coins while he was in Singapore. When X arrived in Manila, he also caused or facilitated its importation into the country. The importation of the coins which he himself counterfeited. Question: what is X's criminal liability here? X is liable for 2 counts of violation of Article 163, one for counterfeiting and another for importation. Now, let's go to the last punishable act of this article, the uttering of false, fake, or counterfeited coins. Now, to utter means to circulate or to pass false or counterfeited coins. It includes the delivery or the act of giving them away. A counterfeited coin is uttered when it is paid, or at the very least when the offender is caught counting the counterfeited coins preparatory to the act of delivering them, even though the utterer may not obtain the gain he intended. Take note, however, that mere uttering of false or counterfeited coins without proof of connivance with the counterfeiter or importer will not make the utterer liable. Example: X is in possession of 4 counterfeited 20 peso coins. He doesn't know the same to be false or counterfeited. X then uses the said coins to purchase some items at a sari-sari store. Question: is he liable for uttering in Article 163? The answer is an obvious no. he did not act with malice or criminal intent. He acted in good faith when he used the same. To be liable, not only must X be aware that the coins are counterfeited, there must also be proof that he acted in connivance with the counterfeiter or importer. Another example. X is in possession of 4 counterfeited 20 peso coins. X knows the same to be false or counterfeited. He then uses the said coins to purchase some items at a sari-sari store. Question: is he liable for uttering in Article 163? The answer is still a no. Mere knowledge that the same is counterfeited is not enough. It must be coupled with proof that he acted in connivance with the counterfeiter or importer. He can be held liable instead for estafa by means of deceit. Third example. X, the importer of the counterfeited coins himself, also uttered the same. Question: what is X's criminal liability? Answer: X is liable for 2 counts of violation of Article 163, one for the importation and another for uttering the said coins. The requirement of connivance is no longer necessary owing to the fact that the importer and utterer are one and the same person. He cannot connive with himself, right? Now, this is very important. Who is the offender in Article 163? Any person, whether a private individual or a public officer, for as long as he makes or imports or utters a false or counterfeited coin. Another question. How many coins should be counterfeited, imported, or uttered to make the offender liable? The article does not specify. Hence, it is submitted that even one false or counterfeited coin is enough to constitute a violation under this article. Now, what kind of coins are subject of the counterfeiting, importation, or uttering? They are any coin of the currency of the Philippines and any coin of the currency of a foreign country. Now, with respect to coins of the currency of the Philippines, there is no longer any distinction as to the penalty to be imposed, whether the coin is a silver coin or a coin of the 10 centavo denomination or above, or below the 10 centavo denomination. And finally, the offender in Article 163 is liable even if the counterfeited coin has been withdrawn from circulation or no longer in legal tender. What I mean by this is, even if the coin that is imitated is no longer in circulation or is no longer legal tender.